Not state anywhere that he knew.
The accused Abubakar Kalungi, who was facing trial in the High Court Criminal Division in the murder of ASP Muhammad Kirumira and Nari Nyareste, was at 11:30 a.m. already in court to receive a judgment from the presiding Judge Margaret Mutonyi. Judge Margaret Mutonyi said prosecution failed to produce evidence against Abubakar Kalungi, not even pressing him at the scene of crime to commit the alleged murder of ASP Muhammad Kirumira. She also added that there was contradiction in the evidence from the prosecution.
The eyewitness mentions 2 motorcycles with 2 riders on each, and they all actively participated in the murder. The first one shooting in the air to scare off anyone and the cars from approaching the murder scene, while the other was shooting directly at the deceased. The evidence of the eyewitness does not corroborate the charge and caution statement at all. A charge and caution statement, which is treated as a confession, must be unequivocal. It must be unequivocal. It must show that he committed the offense.
Judge Mutonyi also ruled that the statement made by witness AIP Walimbwa Stephen from the accused Kalungi Abubakar was illegally recorded, since it was recorded in English, while the accused knew Luganda.
There is no evidence that he explained to him in a language he understands, yet he boasted of over 30 years' experience as a police detective. The same happened on each page where he recorded in English and just had the name of the accused written as signature. On the last page, that's page 26, he stated that that is what I can state, and the names of Kalungi Abubakar was written. AIP Walimbwa then wrote, charge and caution statement read back to the maker, being translated into Luganda by me, Detective AIP Walimbwa Stephen, and he has confirmed as true and correct. He appended his signature and rank of Detective AIP Walimbwa Stephen.
Court also added that the accused Kalungi was forced to confess that he killed ASP Muhammad Kirumira and Nari Nyareste after he had been tortured.
In summary, the accused denied participating in the gruesome murder and denied having made any voluntary confession in regard to participation in the alleged murder. He does not state anywhere that he knew the reason why Katerega wanted him to locate the vehicle belonging to Kirumira, or that he knew that they were planning to kill him, and he was to assist them in the murder by locating his motor vehicle, which would make him an accomplice in crime. PW6, an eyewitness's narration of what transpired on that fateful day and hour, is very different. He described the motorcycles as sports motorcycles, and that there were 2, not 1, as stated in the charge and caution statement, which was retracted.
Court, however, accused prosecution for failure to prove its case by placing the ADF terrorists in the killing.
This is a case that had no direct evidence on participation, and as such, investigation should have been wider and thorough to show the inculpatory facts are inconsistent with the innocence of the accused. In view of the above, my final conclusion is that the prosecution failed to discharge its burden of proof on the ingredient of participation, as it relied on fanciful speculation that it was the ADF rebels that killed the 2 deceased persons, without even adducing any evidence linking the accused to ADF rebels. Whoever led the investigation in this case killed it the moment the focus was on the ADF operatives, yet no evidence was adduced before court linking the accused with ADF.
However, court condemned police for killing a one Abdallah Kateregga, who was the alleged prime suspect in this matter.
She did not have details of the subscribers of the numbers, yet documentary evidence must speak for itself. Nothing of significance was adduced in court to prove beyond reasonable doubt that the subscribers or users of the numbers under investigations were Kalunji the accused and the one Kateregga. There was no direct or circumstantial evidence establishing that the two had a common intention to murder the two deceased persons in this case. This is a case that had no direct evidence on participation, and as such, investigation should have been wider and thorough to show the inculpatory facts are inconsistent with the innocence of the accused.
Judge Margaret Mutony acquitted Abubakar Kalunji of the murder of ASP Kirumira and Nali Nyareste.
I agree with the opinion of the two leader sisters that the accused should be acquitted, and I hereby acquit him of the 2 counts of murder. He should be released unless held over some other lawful charges. The prosecution is free to appeal against this decision if it is not satisfied.
Era yakola okunoonyereza omusango guno omusango yakuta bwe yateekera oludobye kubayekera ba ADF nga tereeta bujulizi obwo obugatta abantu abo kubayekera abo nzikiziganya n'abawozi ba kooti ababiri omuntu ono avunaanibwa yeegereza emisango egyo ebiri egy'okutta omuntu ajja kuteekwa okujjako nga naye emisango emirala.
ASP Kirumira and Nali Nyareste Mbabaz were murdered on 8th September 2018 around Blenge, Kampala suburb.
Every piece of evidence that was brought by the state, and also consider our evidence as defense, consider the law as it is, and found that whatever was brought, including charge and caution statement, was a mere piece of paper which had no evidential value, and all the allegations and the fact that the alleged charge and caution statement was obtained through torture, and the accused person now, the freeman, did not sign to acknowledge whatever was stated in that charge and caution statement. So we are happy that justice has prevailed.
Sirina bingi byakwogera bingi omanyi okuyimirira omuntu omu bwoti ku baana abasukka ku omu si byangu, kusomozebwa kungi, abaana tebasoma amazima gennyini.
Mpulira essanyu era ne nebaza Allah nannyini nteekateeka amuteekeddeteekedde, kubanga tegabadde magezi gaffe, tezibadde ssente, tebibadde ebigambo byaffe bingi. Allah yenanyini byonna era yatulereddewo obufulumire, yatulereddewo obwangu. Sabayi Allah yongere n'okumukuuma nga tebaddamu mukwatako. Sabayi Allah tusemberezeeyo abalabe bonna n'abalala basigaddeyo mu kkomera abataasa abajjeyo kubanga tebalina musango babalanga bwemage. Sabayi Allah ayongere otusaako obukuumi bwe era yenanyini nteekateeka ateekereteekera abasigadde bonna.
Ndi muganda wa Kalunji, ndi musanyufu okuba nti nno mukulu wange ateebebbwa oluvannyuma lw'okubeera nti abadde avunaanibwa ebbanga lya myaka 4 ng'avunaanibwa ebintu by'ataakola, naye kiruma mu butuufu kuba nti amaze ebbanga ddene nga bamuvunaana ebintu by'ataakola. Naye nsaba abakuumaddembe ne poliisi bonna babeere bavunaanyizibwa okubeera nga bawuliriza amateeka nga bwe gasomeddwa, babeere nga bamuleka atambula agende mu ddembe addeeka, kubanga okubeera nga ayina abaana abasukka mu 5 abali mu 8 ng'abaana bonna tebasoma, ng'abaana bonna yali abeera nga abaweerera abaliisa, byonna byayimirira olw'okuba nti nno kitaabwe taliiwo. Bannange si kintu kyangu, naye nabo bajja kuba basanyufu okulaba nga kitaabwe akomyewo mu maka gaabwe okubeera nga basanyuka naye nga ndi musanyufu ku lwekyo. Kyensaba kiri kimu nti nno
Yes, Assistant DPP, will you hold the brief for Carol Tabaru?